Welcome to the Legal Masterminds podcast. This is where sharp minds meet sharp law. We break down landmark cases, teach strategy, and keep you steps ahead. Whether you are a lawyer, law student, legal intern, or just someone who loves smart conversations. Inside this podcast, we do not just talk law, we unlock it. Want to join the community behind this podcast? Send us a DM. We promise you will love it here. Now let us get into today's case.
This is a summary of Ecobank and 7 others versus Tempo Energy and 9 others. A decision of the Court of Appeal, Abuja Division. Delivered on the 25th of April, 2025. It began as many commercial disputes do. Tempo Energy had secured an ex parte injunction from the trial court in January 2021. Restraining Ecobank and its co-defendants from taking steps on certain oil and gas assets. Naturally, Ecobank filed an application to discharge that injunction. Other parties also filed various motions, clogging the docket. By the 22nd of February, the court took charge. It consolidated all the pending applications for hearing on a future date. It also scheduled a ruling on Ecobank's oral argument challenging the injunction's validity for April 14th. These were ordinary case management decisions. No final judgment. No new injunction. No clear win or loss for any party. Yet Ecobank saw injustice. It filed an appeal immediately, claiming the court had erred in consolidating the applications and had breached its right to be heard. It also argued that the delay in ruling on its challenge to the injunction was a miscarriage of justice. The real shock came next. Ecobank went further. It asked the Court of Appeal to stay proceedings in the trial court, pending the outcome of the appeal. And that stay was granted. The main suit froze. For 4 whole years. The Court of Appeal had to untangle a knot it helped tie. Justice Abam, delivering the lead judgment, began with a firm reminder. Not every courtroom decision is appealable. Under Section 318 of the Constitution, a decision includes rulings that settle legal questions. Yes, consolidation and adjournment qualify as decisions. But that alone is not enough. The real issue was whether those decisions were the kind the law allows you to appeal without leave. Ecobank's appeal raised 4 grounds. 2 of them challenged the ex parte order made back in January. But the trial court had not revisited that injunction on the 22nd of February. So what exactly was Ecobank appealing? You cannot appeal a ruling the trial court did not deliver. You cannot fight shadows. The other 2 grounds attack the court's choice to consolidate and to adjourn. Now, those are discretionary acts. They involve questions of both law and fact. And by law, you need leave of court to appeal such decisions. Ecobank never asked for leave. So those grounds were also struck out. In short, all 4 grounds were fundamentally flawed. What remained was the stay of proceedings. A freeze placed on the main suit for 4 years, without merit. Was that justifiable? Justice Aban did not mince words. He described the appeal as a calculated attempt to stall the case. A textbook example of abuse of court process. An appeal, he said, must be filed to vindicate rights, not to paralyze justice. Justice Muhammad agreed. He stressed that the burden on an appellant is not light. You must show that the trial court made a clear legal error. And that the error led to a miscarriage of justice. Ecobank had done neither. Justice Okoro added that courts have up to 90 days under Section 294 of the Constitution to deliver rulings. An adjournment within that period is not a denial of justice. It is part of managing a heavy docket. He ordered the case remitted for accelerated hearing at the trial court. The court also awarded cost of 1,500,000 naira against Ecobank. Here are the takeaways every legal professional must remember. First, always identify what exactly the trial court decided. You cannot appeal what does not exist. Second, classify your grounds carefully. If they involve mixed law and fact, obtain leave before heading to the Court of Appeal. Third, resist the temptation to use appeals as weapons. A meritless appeal may not just fail, it may backfire. In law, timing and purpose matter. A technical right, used wrongly, can become a costly mistake. This case is a reminder that appellate courts are not havens for procedural mischief. They are temples of justice. Treat them as such.
Hope you enjoyed this case. Now imagine having access to minds that break down the law like this every single week. Why not join our Legal Masterminds community today? We do more than analyze cases. We build legal giants. One thing we promise you, you will stay up to date with Nigerian law, master powerful legal strategies, and connect with people who think just like you. Our next meeting is this coming Saturday at 8 p.m. West African time. We are always prompt, no delays. Send us a DM to join. The seat is yours if you are ready. Till next time, stay learning, stay bold, stay sharp.